My name is Charles Cadwell. I'm currently working at the Urban Institute, a think tank here in Washington, but I've had the privilege of working with Stuart Kerr on rule of law issues around the world for now several decades. Listening to our earlier panels, I realized we should rename this panel perhaps, and that's, which is currently, I guess, called Legal and Regulatory Challenges in FinTech. The first panel was called Challenges of Regulation. I think I might relabel this one More Challenges of Regulation in Africa. We're very fortunate today to have a distinguished set of people who are going to expose you to a lot of issues in a real hurry. And so some questions we're going to address is whether FinTech, technology-enabled finance, is a development in Africa that can be transformative and overcome lots of the obstacles that we heard about in the first two sessions. Or are the underlying rule of law and regulatory constraints such that simply adding the word tech to fin doesn't really solve the problem? To cover this topic in the very few minutes we're going to have, we're going to proceed this way. Our main speaker, Dr. Anton Didenko, will set the stage for us for about 20 to 25 minutes, and he knows I'm going to hold him to that, so he's going to, if he's speaking too quickly, you should wave your arms and we'll slow him down. He's just come from a workshop on this topic in South Africa that he organized with the Bingham Centre, and so he brings current perspective as well as his research. He'll be followed by comments from two people with enormous complementary expertise. Corey Stout on your right is with Axiom, where they make investments in financial services and technology financial services in Africa. And so her perspective is closely informed. Tazeen Hassan in the middle is from the World Bank, and where she's an expert on many things, but among them, women in the law. And I want to hold up her book that was published recently and recommend it to you. The bank doesn't charge for this, do they? No, it's a free book. But still, I've just come from a conference on women's legal empowerment in South Asia where her book was an incredible resource on issues, and particularly here where the question is whether FinTech helps women overcome the extra barriers that they face in access to all sorts of institutions, including financial services in Africa. With that, so I'm not taking any more time, Anton, the floor is yours.
Thank you very much, Chaz, for the introduction. Ladies and gentlemen, we live in a digital world. Technology plays an important role in our everyday lives. Mobile, or since we're in the US, I should say cell phones, have become almost a necessity. And our daily routines are unthinkable without the internet. And this said, Africa is no exception. Digitalization proceeds at high pace. According to the Ericsson Mobility Report, Sub-Saharan Africa remains the region with the highest growth rate in mobile subscriptions globally. The penetration levels back in 2010 was just below 50%, and now the forecasts indicate that close to 100% penetration is achievable by 2021. According to GSMA, between 2015 and 2020, mobile internet penetration will numbers will grow from 25% to 41%. In the world of finance, technology creates opportunities that have not existed before. In Kenya, mobile phones have been used as an instrument of financial inclusion, providing easy access to formal financial services to the majority of the population. Online crowdfunding platforms are being used to raise finance for local projects. The list could go on. The intersection between finance and technology is often abbreviated as FinTech, and this is the topic of our panel and the focus of this presentation. My presentation will consist of three parts. First, in the introduction, I will answer three basic questions. What is FinTech? How is it linked to SMEs? And why it should be regulated? Then I will cover and list several key challenges in the FinTech regulation specific to Kenya and South Africa. And finally, I will provide certain suggestions for improving the fintech regulatory framework in these two jurisdictions that was inspired by our consultations with the stakeholders in the two jurisdictions. So the question is, what do we call fintech? Is it an industry, a technology, an activity, a business? Well, in reality, it's a very complicated question and there is no right answer. I won't bore you with the academic debate. I'll just refer you to the two most recent international attempts to define fintech in 2017. The Financial Stability Board defines fintech as, I quote, technology-enabled innovation in financial services that could result in new business models, applications, processes, or products with an associated material effect on the provision of financial services. The last part of the definition is critical here because it demonstrates that innovation is not uniform, and in some cases the innovation can be incremental and not really bring any groundbreaking change. And possibly those incremental changes will not be captured by this narrow definition. The European Commission in 2017 launched a public consultation where it defined fintech very broadly as technology-enabled innovation in financial services, and then subdivided fintech into disruptive and non-disruptive fintech. And I think this approach is quite helpful for our today's discussion because we'll keep things general and broad enough. So there are two key points from me here. First is that fintech has an inherent disruptive element. It adds a certain degree of innovation. And second, because innovation is understood differently, the concept is pretty flexible because what was considered fintech in the 19th century will not be fintech today. And obviously different regions, different jurisdictions may treat fintech differently as well. So why is fintech a relevant concept for SMEs? Well, I'll make just four general points. First, the new technology is often developed by startup SMEs. That's what we usually call five guys sitting in the garage doing something on their computers. Second, crowdfunding and peer-to-peer lending platforms can be a viable source of alternative finance for SMEs. A recent initiative in the UK, for example, is the so-called bank referral scheme, whereby major banks refer unsuccessful SME applicants, loan applicants, to alternative finance platforms for funding. Third, some fintech solutions like mobile money were specifically developed as an alternative to bank accounts and bank transfers and therefore are an instrument of financial inclusion. And finally, some fintech solutions like virtual currencies on Bitcoin and others can be used as an alternative investment instrument. So, do we need to regulate fintech or shall we let it go? Obviously, it's a policy question, but we think that there are very good reasons for regulators to keep an eye out on this development. First of all, existing regulations do not often support the emergence of the new technology, which is often the case with the virtual currencies. They don't really sit well with the existing regulations. Second, startups and SMEs working in the fintech space obviously cannot compete with incumbent financial institutions if the regulatory regime is based on banks and bank licensing requirements. And so this means that regulators might be inclined to create certain preferential treatment regime for fintech SMEs if they want to promote the technology. Fintech solutions also may allow greater access to formal financial services to large numbers of unsophisticated parties, especially where there is a high level of financial illiteracy in the jurisdiction, and therefore regulators might wish to protect the people. Existing regulatory models are also not always suitable for addressing the fast-paced changes brought by fintech, and this means that in some cases, for example, with the crowdfunding online platforms, the transition between too small to care and too big to fail is very quick. It can take months rather than years, and therefore regulators might wish to rethink their approaches to the regulation. And finally, some fintech solutions are extremely decentralized. And this makes it particularly difficult for the regulators to find a way to regulate even if they want to. This is particularly relevant, for example, for the blockchain and distributed ledger technologies, which do not have a common center, the single entity controlling the whole business, or the common center of operations. Speaking of the relevance of fintech specifically in the context of sub-Saharan Africa, we note the very strong pro-fintech sentiment in the region. This is obviously because the technology can be used as an instrument of financial inclusion in the region, with over 300 million of unbanked people. And it often means that the choice when we're talking about fintech is not between fintech and the existing banking products, but fintech and nothing at all. And the choice is probably quite obvious in many cases. Another important factor is the lack of high-profile failures in the fintech area in Africa, specifically, as opposed to some other jurisdictions like China. Whereas banking is commonly perceived as being for the rich and being highly bureaucratic. And we shouldn't discount the importance of demographics. Millennials form a large proportion of the population, and they're really fintech friendly. As a result, 13 countries with the highest mobile money user bases in proportion to the population are all located in sub-Saharan Africa. And 54% of global mobile money services are also localized in the region. Interestingly, however, there is quite a low number of highly successful fintech businesses in Africa. Some of the possible reasons have been identified by some of the commentators as the low level of government regulatory support or insufficient quality of infrastructure. Against this background, Kenya and South Africa are the fintech leaders in the region. In the recent report on fintech, on global fintech hubs, Deloitte have listed only two primary fintech hubs in sub-Saharan Africa, Nairobi and Johannesburg, only joined by Lagos as the future fintech hub in 2017. Kenya and South Africa are the regional leaders in alternative finance, although the overall numbers are not impressive, I have to say. M-Pesa in Kenya doesn't really need an introduction, being the most popular mobile money platform in the country, covering over 90% of households. And in 2017, Kenya launched the world's first mobile-only government bond called M-Akiba. Speaking of specific features and challenges in fintech regulation, specific this time to Kenya and South Africa, I want to first cover 4 points that are relevant for both countries. Well, first of all, we don't see dedicated fintech regulation, and so fintech companies end up being regulated by a standard array of laws and rules, including financial services regulation, company laws, electronic communications rules, and so on. We also don't notice a general fintech-oriented strategy, and therefore regulators end up trying to solve the problems as they emerge. And probably the good example is the regulatory response in both countries to the Bitcoin and other virtual currencies when the banking authorities in two countries responded with warnings and position papers on the risks underlying these technologies. We notice the development of principles-based rules in fintech regulation in South Africa. One of the examples is the Protection of Personal Information Bill, known as POPI, which lists 8 principles of data protection. And in Kenya, a recent consultation paper on Sandbox regime concluded, I quote, that regulatory nimbleness, flexibility, and responsiveness provided by principles-based regulation is even more important in the fintech sector, where thriving innovation is the lifeline of a vibrant business enterprise. And finally, digitalization always comes at a cost, and I'm talking now about cybercrime risks. And unfortunately, Kenya and South Africa are also leaders in this area as well. According to a Symantec study, the two countries are respectively the first and second highest source countries in sub-Saharan Africa in terms of cyber attack numbers, malware, spam, and phishing hosts. According to PwC, 32% of South African organizations reported having been victims of cybercrime. And according to another research, Kenya has the highest losses from cybercrime activities in East Africa. To respond to the various challenges, regulators drafted, and legislators as well, drafted the new rules, cybercrime rules, in June and July 2017. They are open for public discussion right now. Moving on specifically to South Africa, I should start by saying that the jurisdiction does have established financial services jurisdiction regulation that is undergoing significant change as we speak. In August 2017, the President signed the Financial Sector Regulation Act, known as the Twin Peaks Act, which is going to create two new regulators, Prudential Authority and Financial Sector Conduct Authority. And so this implies a certain degree of potential uncertainty in terms of future regulation on fintech in the country. Another important change is the introduction in 2015 of the Socio-Economic Impact Assessment System, which we think is a good step in potentially identifying those areas in fintech that warrant priority regulatory intervention. Virtual currencies in South Africa remain unregulated, and the current status quo was summarized in 2014 by the South African Reserve Bank in a position paper that stated that activities related to the acquisition, trading, or use of virtual currencies are performed at the end user's sole and independent risk. There have been reports that the Reserve Bank is considering possibly reviewing the position, and it's very interesting to see whether the regulator is actually considering a state-issued virtual currency, which, if this is the case, might create additional complications for the regulatory regime because of the potential conflict between the state-issued and privately issued virtual currencies like Bitcoin. So it's something to follow. Also, there is no dedicated crowdfunding regulation in the country, and so depending on their structure, online lending platforms may end up being subject to a variety of different laws, although potentially changes are coming up. Moving on to Kenya, it's of course impossible not to mention M-Pesa as the dominant mobile money provider in the country, with almost 23 out of 28 million subscribers and with transactions amounting to 40% of the country's GDP. The potential systemic risks coming from the dominant position of M-Pesa were highlighted in the most recent 2017 budget policy statement. But to be fair, certain attempts have been made to level the playing field a little bit. For example, in 2014, the Competition Authority of Kenya ordered Safaricom to open M-Pesa for competing firms, and there have been discussions of full interoperability of mobile money networks in 2017, although they seem to have stalled. Thank you. In our discussions with the stakeholders, Kenya was commonly referred to as an example of a jurisdiction with regulatory environment lagging behind the technology, and this was certainly the case with the regulation of M-Pesa, which for a number of years, from 2007, operated essentially on the basis of the central bank's letter of no objection, which led to significant criticism addressed towards the regulator, which had to accept that, I quote, regulation generally lags behind innovation, and a pragmatic approach was adopted with regard to M-Pesa. Similarly to South Africa, virtual currencies are not regulated in Kenya, and the Central Bank of Kenya ended up issuing two separate warnings about the risks of this technology. One was addressed to the public, the other to financial institutions. The public warning stated that that virtual currencies are traded and exchange platforms that tend to be unregulated all over the world. Consumers may therefore lose their money without having any legal redress in the event these exchanges collapse or close business. The warning to the financial institutions was stronger. It stated that financial institutions were expressly advised not to open accounts for any person dealing in virtual currencies such as Bitcoin. Failure to comply with this directive will lead to appropriate remedial action from the central bank. And again, similarly to South Africa, there's no dedicated crowdfunding regulation, and so depending on the structure of an online lending platform, it might be subject to a variety of different laws and regulations. And now I'm moving on to the final part of the presentation, that is suggestions for improving the FinTech regulatory regime in the two countries following our discussions with the various stakeholders in the two jurisdictions. Well, the first one is the need for clear FinTech policy are a set of priorities. It may sound basic and self-explanatory, but I need to highlight the importance of the signaling function this has, particularly in respect of SMEs and startups, which usually prefer to stay under the regulator's radar and are not used to being engaged in a mobile phone relationship with the regulator, which is usually the situation with financial institutions. The second suggestion is to enhance the clarity and accessibility of existing financial services regulation targeting startups and SMEs. In our discussions, startups were often referred to as requiring a translator, someone like financial institutions or a FinTech accelerator who is able to speak the same language as the regulator and transfer and explain what's going on. So there are different ways the regulator could approach the problem, could issue explanatory materials for non-experts or provide consultations by staff. The third point was inspired by our discussions with the South African stakeholders and the new project, the new socio-economic impact assessment. We think that it's a very good initiative that can help identify those FinTech areas that require priority regulatory intervention. However, for this system to work, it needs to be comprehensive and avoid the tick-the-box approach. It needs to be independent and verifiable and based on robust methodology. It should count not only the benefit, but the cost of implementing and devising the new rules. Ideally, be both performed on an ex-ante and on ex-post basis. And finally, and I'm lucky to be following Dr. Kobaruka's inspiring speech, it should reflect the perception or the actual level of compliance with the new rules. So it is not sufficient that you have fantastic new rules that might be well written, complicated, if they are not actually implemented. And so if we look at a sample, very generic equation whereby economic impact is calculated by subtracting economic costs, which is D, from the sum of micro and macroeconomic benefits, that is A and B, and C in this equation would be a variable between 0 and 1, which measures the actual level of compliance or the perception of compliance in the jurisdiction. So if there is full perception of compliance, it will be 1, so the benefit will be taken at face value. If there is no perception of compliance or there is no compliance with the rules or the rule of principles, then it can be discounted and essentially we're not getting any benefit, just cost. Some of our discussants in the roundtables suggested regulatory sandboxes as a potential way forward, as an instrument that has already been proposed by the number of jurisdictions. It remains to be seen how these rules are devised, but we stress the importance of rule of law in devising these sandboxes. First of all, there need to be clear selection criteria and methodology. We stress the need to publicize the results of selection applicants and businesses eligible for the sandbox, and obviously all the instances of preferential treatment that can be offered to FinTech SMEs and startups need to be limited and defined by the law, because otherwise the whole sandbox regime might be seen as regulators given an unfair advantage to select businesses and discourage innovation. Obviously, we think that in selecting eligible sandbox candidates, regulators should take into account the resources available to fintech firms. You cannot reasonably compare the resources that startup has compared to resources of incumbent financial institution. And specifically for startups, it's important that the sandbox actually reduces the cost of compliance to be of any benefit to a startup. And 2 more slides. Brilliant, that's perfect, thank you. So we feel that the trend towards a principles-based approach to the regulation of fintech is worthwhile. It can help address the critical issues that are relevant regardless of the type of technology used, such as the need to prevent fraud. It can ensure the continuity of the basic principles of fintech regulation if something unexpected is developed, and we don't know what this is at the moment. And it can also be used as an interim measure to preserve the fundamental basics of fintech regulation once the regulator is coming up with the more specific rules. And on to the final slide, I stress the need for great engagement of the regulator with the fintech businesses. This is because of the so-called holdout startups problem, where the startups feel that a good contact with the regulator is just no contact with the regulator whatsoever. So regulators can be forward-thinking and engage in that dialogue firsthand. We think that the very fast speed of transition from too small to care to too big to fail probably implies the possibility of designing certain specific rules for systemically important businesses that end up being so big for a particular jurisdiction that additional regulatory oversight is required. And finally, while all of these points might be relevant, and while the regulator is devising principle-based approach or sandbox regimes and doing other important things, we think it's critical to, at least in the short term, to focus on preventing the negative impacts of digitalization on the ordinary people, and therefore such as the risk of cybercrime. And in this light, the recent developments, the creation of cybercrime bills in the 2 countries, and published in 2017, is a great step forward. Thank you very much.
Anton, thank you so much for compressing a PhD dissertation level of information into a short period of time. Given the change in our schedule, we're going to be compressed, and I want to leave time for some questions before we have our lunch. But I'm going to ask Corey to talk to us about Axion's investments in this area, and she'll be followed directly by Tazeen talking about the relevance of this to women's well-being. Corey.
Great. Let me turn this on. Okay, hopefully this works. Hi everyone. As Chaz said, I am Coriel Stout, and I'm here representing Axion Venture Lab. So for those of you who are not familiar with Venture Lab, we are a seed stage FinTech investment fund, and we focus specifically on FinTechs that promote financial inclusion. We're a global fund with priority regions being Asia, Africa, Latin America, and the US. We have made about 32 investments to date, half of which are SME lending funds or SME lending companies, and about 30% of our portfolio is in Africa, primarily South Africa, Kenya, and Nigeria. So sitting on the investor side of things, and really quickly, my role at Venture Lab is portfolio engagement management. So I work and lead our portfolio engagement side of our business, which is really focusing on the companies that we invest in post-investment, so helping them scale. A lot of that relates to working through that tension that can exist between regulation and FinTech. Previously, I spent 4 years in Kenya working for a solar energy company, so have background more in operations and dealing with regulation head-on. When we think at Venture Lab of regulation and understanding how regulation and financial technology can work together, we first evaluate the role of regulation and why it's important in markets and for us as investors and for consumers. We also then look at examples of how regulation can be enabling and also examples of how it can be restrictive, and applying those use cases to the actual role of regulation to understand how it can evolve. So for us, regulation, and there's many nuances here, and Anton's paper is great, but we boil regulation down to protecting consumers and fostering innovation. Those can seem clear and simple, but definitely get more complex on a market level. Thinking about ways that regulation can be restrictive, I'll give you a couple examples that we experience within our portfolio. So we have, as I mentioned, half of our portfolio consists of SME lenders. We have two in, actually all of our investments in Africa are SME lending businesses. But two that I want to highlight today are Lula Lend, which provides large supply chain finance loans to companies in South Africa. And then a company called Lydia, which is based in Nigeria and similar, provides working capital, SME lending within primarily Lagos. Neither company requires collateral, and each of them are small, started by both co-founders, and don't have the financial requirements to be certified as banks. So they're non-banking financial institutions, NBFIs, and as a result, they're licensed as such, but they don't have access to funding. And so it really is up to them to raise the capital that they need to lend to SMEs in the market. This means that they need to raise a lot of debt, and this is really, really challenging. For both companies, they've had to limit the amount of loans that they've given out despite the success and high repayment rates that they experience because their access to debt has been limited. So for us, thinking about the regulation that's in place here, both companies are meeting and filling a critical gap in the market. They're helping to grow the SMEs that they lend to. Those SMEs are repaying their loans on time, and yet their growth is stunted due to the regulation that exists. So one example of a way in which regulation has been restrictive to the companies that we work. Another example that we refer to in cases that can be restrictive is a company of ours called eMoney Pool. And they're based here in the US, and they basically digitize savings pools. So more P2P lending, but typically these individuals are lending on behalf of growing their business. eMoney Pool was not allowed to report to the credit bureau because they're not technically lending on their own. It's lending initiated from individuals who are based in the US. However, eMoney Pool is collecting a lot of data on transaction behavior, on lending behavior of consumers who have either no credit score or really thin files and can't access traditional loans. This information could be really valuable to banks, could be valuable to boost their thin file and make it a bit thicker, but they are not allowed to report that data just because it's new. And I think a lot of the regulators in the market are still trying to grapple with what data do we need, who do we collect it from, how do we make sense of the new alternative data sources that are emerging. A couple of weeks ago, eMoneyPool was actually certified to report their data to the credit bureau. So we are seeing advancements. We are seeing a willingness to adopt these more alternative models and embrace them. But again, still a lot of gaps and obstacles to overcome. Now, thinking about the enabling side of things, couple examples here. Obviously, M-Pesa is a huge example, and one of the main reasons why M-Pesa was really allowed or successful when it was launched in 2007, 2008, was because in Kenya there was practically no regulation in place around KYC required for payments. And this is very different in other markets where there are strong regulations in place, and it is challenging for telcos to conduct KYC when payments are in play. Kenya, this wasn't the issue. M-Pesa has obviously been a huge boom. They've spun off M-Shwari, which allows SME lending. So an example of a situation where regulation led to FinTech, mobile payments, which then led to SME lending. Another example that, again, Anton touched on was the regulatory sandbox. We have a recent investment, Bitcoin remittance company in Dubai and the UAE, which is incubated in this sandbox. They are, the regulators acknowledge that, okay, this is something we want to try and figure out. We don't yet know our stance on this, so work with us. Share information with us. Tell us what your learnings are, what your plans are, and as a result, we'll let you continue to conduct business. As an investor, this was a recent investment. This was really important for us to have in place, to know that the Now Money, the company in which we invested, would not be shut down. That mitigates the risk on our end and makes the company more investable. So again, for us, it really is about understanding, okay, when can regulation be enabling? When can it be restrictive? It's challenging. It is a space where it's not black and white. It's not going to happen overnight. But what we're seeing is regulators are increasingly adopting and embracing technology and want to find a way to work with FinTech. So we're optimistic about the role that regulation can play in driving financial inclusion, especially with SME lending. So.
Thank you very, very much. We're going to move directly to Tazeen. And while she's speaking, though, since we will have such limited time for questions, be thinking about your questions for any of the speakers right now.
Well, thank you. It's been I'm learning from the conversation on the stage itself. It's been very interesting, both from Anton and from Coriel. And I think I'm just going to add another dimension to the huge potential that FinTech has. And I think there's a recent McKinsey report that says that digital financial services could give 1.6 billion individuals access to financial services for the first time, and more than half of those would be women, so around about 880 million. Now, it's a new space, and that's what makes it exciting. It's innovative. It doesn't follow the traditional banking structures, and so there are advantages for women in this space, more kind of flexible working hours, more kind of control, less of the many of the kind of restrictive structures that were there in the traditional banking sector. But at the same time, I want to kind of add a few words of a caveat, and that is that it has this great potential, but many of the same kind of barriers that prevented women from accessing traditional banking services and participating in the traditional banking sector could still be at play in the FinTech space. And so a few kind of words as to how women can be potentially excluded from this transformative space. We hear there's still a digital divide, that we find that, that there has been a great deal of development in developing fiber optic networks in Africa and and access to the internet, but internet penetration for women is lower. So it's 21% in the least developed countries for men and 14% for women. When it comes to access to mobile phones, again, these same kind of gender gaps remain. So 1.7 billion women in low and middle income countries don't own mobile phones or cell phones, and they're 14% less likely to own them than men. So we see that there are great success stories, Kenya, South Africa, and I'll just mention another country, Cote d'Ivoire. Mobile money access is the same for men and women. The figures are pretty much the same. But in other countries in sub-Saharan Africa, Niger, for example, there is still a great disparity in women's access to cell phones and the internet. So what explains these disparities? And this is where our report, Women, Business and Law, is kind of is attempting to show, where these kind of barriers and enablers to women's participation in the space as entrepreneurs, innovators, and consumers are. So we're a sister publication of Doing Business, and we look at the global, which has been mentioned earlier, and we look at the kind of discriminatory legal frameworks that impact women's entrepreneurs and as their ability to work in the labor market. And one of our key findings is that 90% of countries still have at least one discriminatory law on the books. And that this type of discrimination could mean that there's fewer women attending secondary school, fewer women-owned businesses, fewer women in the labor force, and a wider gender wage gap. So the kind of issues that we look at are, for instance, women's access to property. And this is fundamental, because if you have laws that do not allocate assets within a household equally, particularly in marriage, you find that women will then fall behind in their ability as to be consumers, their ability to invest in education, their ability to start businesses, because those assets are needed as collateral for them to start businesses. And the IFC has, there's a study that's indicated that there's a $300 billion financing gap for women-owned SMEs. So this is something that is really crucial to understanding where these kind of disparities begin from. And they begin at a very basic level. You have inheritance laws that are unequal. You have laws which are called marital property regimes that do not give women the same rights to property within a marriage as a man. Then there are mobility restraints. There are 17 countries around the world where women cannot, neither married women need their permission to work outside of the home. There are basic restrictions. I believe that Niger still asks for a woman for her husband's permission to open a bank account. I personally have been working in the Democratic Republic of Congo, where the family code prevented women from registering a business, married women from registering a business, getting a loan, opening a bank account, going to court, signing a contract, and registering land without their husband's permission. And what Dr. Gabaruku said recently in the earlier session was that these are kind of leftover laws. They're laws that were incorporated from the Belgian family code of the 1950s that have now been reformed in Belgium, but are still in the books in DRC. And we successfully reformed those laws in partnership with the government, and they were reformed last year in 2016. So these are very basic barriers. There are issues on the data space. It's that at the same time that this can be a huge boom. We do cover, for instance, as Coriel mentioned, whether MFIs and credit bureau and retail institutions, utility companies supply data to credit bureaus. And so this is, which then can enable women to build up a credit history. We do not cover yet whether mobile money providers do, and I think that probably is a great space for us to move into, so I'm already kind of writing that down. But I think these are the kind of issues that can help women build up a credit history, but at the same time, on data, there are kind of privacy issues as well, that for women to have autonomy within a household, and the fact that they have gravitated to mobile money is because their transactions are private within the space. And so there has to be also kind of protections in this area for women. There's a new, many startups in the psychometric testing space, which again is helping women build up credit history, where they look at patterns of usage, women's personal information, such as where educational background, and to assess risk as well when it comes to a lending portfolio. But at the same time, when there are great innovations in the space that can help women, we have to make sure that those don't, again, incorporate implicit biases against women, as women in some way, that kind of the lack of educational backgrounds, or their kind of, and the lack of networks would also kind of count against them when it comes to this new innovations in the space. Now, we're turning to the other end as women in the FinTech space, as innovators and leaders. And again, the numbers are not encouraging right now. In terms of women leaders, I think a recent report, 4.5% of women as FinTech leaders in the top 50 companies in this space. So what can be done to make sure that FinTech doesn't follow the same pattern as the traditional banking space was at its inception? One thing is in the regulatory sandbox to make sure that it's the eligibility criteria doesn't exclude women, and does reach out to women-owned FinTech spaces. Also, to kind of look at the composition of FinTech companies. Are they providing an enabling environment for women employees? I've just come from the launch of another report that we've been working on with the IFC on childcare, and making the business case for childcare, which was launched this morning at the World Bank. And so, again, making those kind of issues forefront as to getting women in the pipeline as leaders in the space. We can take lessons from other environments. For instance, there are initiatives on making women-owned companies part of the global value chain. And one way of doing that is looking at procurement laws. And so public sector procurement laws must have at least 30% of women as part of the kind of the contracting and tendering environment. So this is really an exciting space to be working in, and we're going to be launching a new report ourselves on women's financial inclusion in the law, which will be coming out in March of next year, and I've been looking at this space specifically. But it's also good that the entry points for kind of gender and women's inclusiveness are identified at the beginning. of this, because it is at the very beginning. And experience has shown us that if it's an afterthought, it sometimes takes a lot of catching up for the space to be to level the playing field. I was a barrister in London at one point in my career. Huge kind of progress in the number of women barristers there, but certainly it wasn't kind of a very, when I entered a few years earlier, what had happened was that women could not order a drink directly from the bar themselves, and that got changed a few years before I arrived. It's now a completely different space, and that's because, again, education, encouragement of women going into the field, and a lot more kind of enabling factors for women to stay in the field afterwards. So I think those kind of policies need to be looked at more closely in the FinTech space as well.
Thank you both very much. Our time is short, but I want to make sure we have time for your questions. So if you have a question and can raise your hand, we've got a microphone here. Any questions? I know I have some if you don't. Several of you have referred to things that make me think the work I've been doing on the political economy of development and the fact that there are stakeholders in the status quo. And so this balancing innovation and entrepreneurship on the one hand and consumer and investor protection on the other is not just a simple trade-off. It involves real stakeholders. And so I guess a question I have is, even though FinTech is so new, are there associations of, how is FinTech organized to address this problem when you've got bank associations, you've got insurance associations, you've got the regulators themselves. Who's on the other side, or are FinTech companies by themselves? I guess I'll direct this at Anton and at Corey, since you're in that side of the business.
Sure. I think you're asking a very important and complicated question because of how dispersed the FinTech landscape is. And so when we're talking about FinTech and the voice the FinTech as a whole might have to influence the regulatory decisions, this is particularly complex because FinTechs are not only small, they operate in vastly different spheres and areas of technology, virtual currencies on the one hand, mobile money on the other hand, and these do not always overlap. So in our consultations with the stakeholders in South Africa and Kenya, this was flagged as an important concern, the fact that it is unlikely that the business will organize itself at this stage unless we're talking about associations limited to particular products or technologies. So this is certainly something I think regulators might look at when designing their approach and be proactive rather than wait for the business to organize itself when the business is so dispersed inherently. I'm not sure what the other speakers think.
Yeah, it is a complicated question. I wish I had a better answer, and I think it's something to flag. I just think the nature of FinTechs are they're small, they're trying to prove their model, especially the ones that we invest in, and what they're doing is, and the data they're collecting is proprietary, and that's their value. That's the core of their business. That's how they're going to raise future money. That leads to the valuation of their company. And as I mentioned, for companies where there's a huge burden on them to raise debt because they are classified as non-banking financial companies, there's a lot of competition in the space. And so I think there should be a collective effort, but at this time, there is the need to prove business models, to raise money, and that means, and you're competing against a finite amount of money out there, so there's going to inherently be secrecy and competition in the space. On the flip side, I also think FinTech is so broad that you do see some more narrow types of organization, especially around, and I'll speak to the solar space. There's an organization called GOGLA, the Global Alliance of Off-Grid Lighting, Global Off-Grid Lighting Alliance. And what they do is they now have organized the vast number of solar energy companies, especially in East Africa, but all over the world, and have quarterly meetups for them and an annual conference. And that's a great example of a way to think about the FinTech space in specific sectors and to actually organize around that. So as it gets more mature and develops, I think we'll see more of these associations.
I just add to this that the existence of organizations like Axion is particularly helpful for the regulators, because it's very difficult to obtain reliable data from the businesses themselves that are really under the radar in most cases. But financial institutions that are working with the fintechs and startup accelerators are often conducting due diligence, technological due diligence, legal due diligence on the companies they invest in. And so they do accumulate a lot of important data that the regulators could rely on while thinking about the ways to interfere.
And I suppose to an extent that an outside organization like Axion ends up setting an informal standard of sorts that may not exist in the market yet. Tazeen, I've just come from a conference with women from 5 countries who were worried about labor force participation, which is different than SME participation. But I'm going to ask you a question I haven't prepared you for. In that instance, the huge barrier to women's labor force participation was access to childcare and concerns about violence, getting to and from work and at work. In the area of SMEs, are regulatory burdens becoming an SME a bigger barrier from your study, or are these problems that constrain women's activity outside the home in general a barrier?
I think what I've really begun to really understand is everything is linked. If you don't, for a woman, if she doesn't have childcare, if she's not able to get to work safely, securely, if she's not able to be in the workplace without without harassment, all these things are preventative measures. Prevent women from basically entering the labor market, either as employees or as entrepreneurs. It's the same space. So when you ask about underlying constraints to women and what are the barriers, yes, there are barriers in formalizing a company, in formalizing getting collateral, but more fundamental barriers are the fact that, as I say, they don't have the same access to assets, they're time poor because of childcare constraints, they're multitasking, and that there isn't kind of the protections in the workplace that would enable them to have a baby, get back to work, be on the same track, and also encourage both parents, men and women, to be able to share household responsibilities. So, for instance, parental leave, paternity leave, as well as maternity leave. So these are kind of the issues that are basic barriers, and which will also explain why the needle has not changed on labor force participation in some countries. And that also why there has been a huge amount of progress, but there are still kind of these discrepancies, gender gaps when it comes to women growing their businesses, moving out of the SME space, becoming also in senior positions within, let's say, the banking sector and in other sectors. So everything is linked. You have the personal as well as the kind of more kind of formal enabling structures. And so I think that's what I think that, without, if a woman has to take care of the child and that's her responsibility and nobody else's, then, how do you expect that woman to have the same time as men to be able to do everything that's needed to get where you need to be in a space.
So if we reconvene 5 or 10 years from now, we may see, we'll be able to tell, we'll have a lot more data, first of all. There'll be a lot more FinTech experience. There'll be, so far we hear about successes. We don't have time to ask Corey to tell us about the firms she did not invest in, and why she did not invest, whether those were specific to the firm or to the market they were going into. And we will have a lot more data about the barriers and the obstacles, whether indeed it is, in this case of women, perhaps even outside the financial regulation area, or whether it's in the financial regulation area. And we may have some famous disasters at that point too. Anton was telling me beforehand about the FinTech collapse in China that left a lot of people, I guess, without their money. But in any event, but we are pressed for time, and so I have to adjourn right now.